Welcome to C-Tute. Today, we're diving into a high-stakes topic, data privacy in Switzerland, and how you can stay compliant in 2025. The rules have changed, the expectations are higher, and whether you're a startup, a SaaS company, or an enterprise, navigating Switzerland's evolving privacy landscape is essential. We'll break down exactly what the new Swiss Federal Act on Data Protection, or REV-FADP, requires from your organization and how it aligns with GDPR. We'll also walk through practical steps to protect your business, your customers, and your reputation. Let's get started. Switzerland's revised data protection law, the REV-FADP, came into effect in September 2023. This update modernized the 1992 framework, bringing Swiss law closer to the GDPR standard in Europe. The key message? Even if your company is not based in Switzerland, if you process the personal data of Swiss residents, you're on the hook. REV-FADP now mandates that organizations document their processing activities. That's the ROPA. It also requires data protection impact assessments for high-risk use cases. And if a breach occurs, you're expected to notify the Federal Data Protection and Information Commissioner, or FDPIC, without undue delay. These are the baseline obligations for any organization operating in or serving the Swiss market. So what makes compliance in Switzerland different, even from the GDPR? First, data localization still matters. Swiss companies, especially in banking and healthcare, often expect data to stay within Swiss borders, even if the law doesn't strictly require it. Second, Switzerland has less patience for opaque AI systems. If your product uses AI or machine learning that can't explain how it makes decisions, it may not pass regulatory scrutiny. Third, the FDPIC, the Swiss Data Protection Authority, now has more teeth. While it can't issue GDPR-style fines, it can file criminal complaints with cantonal authorities and order corrective actions. And finally, there's no transition window. If you're audited today, you're expected to be fully compliant. First step, get your data house in order. That starts with a full audit. Catalog every piece of personal data you collect. That means employee info, customer records, marketing leads, analytics data, even backups and logs. Then classify by sensitivity. Is it basic profile data, or is it financial records, health details, or biometrics? Next, map where that data is stored. AWS Frankfurt, Google Cloud Zurich, a spreadsheet saved in someone's Dropbox. You also need to trace how the data moves across countries, systems, and services. Knowing your flow is the first step to controlling it. Step 2, your audit feeds into your record of processing activities. This is your formal documentation of every processing activity your company performs. It needs to include why you're processing the data, what kind of data it is, who it's shared with, where it's stored, and how long you'll keep it. Think of it as your compliance resume. If the FDPIC ever investigates, they'll ask to see it. And if you use cloud services or third-party vendors, you'll need to include those too. A good ROPA is detailed, accurate, and regularly updated, not a document you forget once it's filed. Step 3, for any system that involves risk, especially around automation or AI, you'll need a DPIA. A data protection impact assessment is exactly what it sounds like. A pre-launch risk evaluation. Say you're deploying an AI-driven fraud detection model, or adding facial recognition to a mobile banking app. These are red flags for regulators. Your DPIA should show you've thought about risks, consulted with stakeholders, and designed mitigation strategies. Doing this early not only avoids legal issues, it improves your architecture. Privacy by design isn't just a buzzword, it's required by law. Step 4. Here's a trap many companies fall into, assuming their vendors are compliant without checking. If you use SaaS, cloud, analytics, or marketing tools, you're sharing data, and that makes you responsible. You must have valid data processing agreements in place. These should clearly define responsibilities, rights, and security requirements. Ask for a list of sub-processors. Many vendors update this monthly or quarterly. Prefer vendors that host data in Switzerland or the EU, and always verify certifications. ISO 27001, SOC2, etc., and make sure breach notification timelines match what RevFADP expects. Step 5. You can build perfect policies and still fail if your people aren't trained. Privacy training isn't a checkbox. It's a continuous investment. Start with company-wide awareness sessions. What counts as personal data, what the risks are, and how to report incidents. Then run role-based training. Developers need to understand secure data handling. Marketing teams need to know how to collect consent. Support teams need to spot red flags. Use breach simulations, even basic ones. They teach people what panic looks like and how to respond. And yes, track who completed training and follow up if they didn't. What happens if you don't comply? First, enforcement. The FDPIC can issue corrective orders and refer serious violations to criminal authorities. Second, lawsuits. Under the new law, individuals can file claims for damages. That could get expensive. But the biggest loss? Your reputation. Privacy is part of Switzerland's identity. Losing user trust is often worse than any fine. And yes, track who completed training and follow up if they didn't. Let's recap what you need to stay compliant in 2025. Run a full data audit, build and maintain a ROPA, conduct DPIAs for risky tools or models, hold your vendors accountable, and review their contracts regularly. Train your people like your business depends on it, because it does. And don't treat this as a one-time project. Review your setup at least once a year, or anytime your systems change. Compliance isn't just law, it's leadership.